We're going to pick up now on how to do the brief. First thing is that your brief is a memorandum. It's your fundamental way of communicating and persuasion, so keep that in mind. Remember, you're always trying to do the same thing. You're always trying to argue for an acceptance of the facts you put forth and also the interpretation of the law that you're building your case on, and an analysis of those facts as they fit that law. That's the drill. So the first thing in your brief is an introduction, and we're going to go through each of these, and then an argument, and then a conclusion. So it's pretty consistent. All right, so the introduction. The first section of your supporting brief is always going to summarize the facts. Facts are the fundamental thing that is used to construct the argument. Think of it as bricks, if you will, in a building. The opposing brief, right, looking for summary judgment, will emphasize those material facts that are in dispute, right? It's about arguing first what the facts are that should be considered. Then the argument moves to the looking at the argument itself, which would include, obviously, the particular statute or whatever that you are incorporating or using or what have you. And then that final part, which is obviously the conclusion again. So for each statement of fact, right, in the introduction, you should cite to a source. The underlying evidentiary sources, evidence that you've got that should already be in the record, might already be in the record, or add to the record in your summary judgment materials. Remember, that's what we're talking about here, right? Okay. The second, paragraphs in your separately filed statement of facts, which in turn will cite to underlying evidentiary sources. So you're organizing it now. You're organizing it based on paragraph and the like. You can also use the introductory section as a summary of your argument, or a combination of facts, procedural history, and summary of your argument. In other words, you have to make a decision about how much to include in your introduction. The upside of including more is that you give the individual or individuals reading that brief, you give them not only background, but you give them basically all they need to understand the landscape you're dealing with and all that you need them to be able to sort of incorporate. You're trying to influence. So you come up front in the introduction and lay that out so they have everything they need to begin to formulate an opinion, or do you want to lead them through your argument and the like? So you're going to have to do that anyway. If it's so included in your introduction, you're going to expand on it. But again, it comes down to time. Think about the panel of judges or the judge that is going to be reviewing this thing, having all of those facts and the like up front, and the argument, even though in brief, gives them solid ground upon which to sort of follow your argument through. It's a judgment call. So then you're going to get to the argument. That's the second thing. Now, again, the argument is all about persuasion. You're trying to persuade the court to buy into your interpretation of the facts as they relate to the underlying law that your case rests upon, right? You've got to think about the legal questions, and you've got to address them. That's critical in the argument, right? So if the court determines that material facts are not in dispute, so we've agreed on those, or if the parties have stipulated to the absence of factual dispute, which we talked about already, they've accepted that these are the facts, no one's disputing it, these are well settled, there's no reason to argue them, because if you do, they're readily provable. That's to say that if you're going to argue that this is a fact in dispute, you better have some grounds for doing that. In the example we use, you can't make the argument that, the person wasn't employed. Well, it's clear they were. You don't argue that. It's tiresome. It's worse than boilerplate. It has no real place. There's no value to it. All right. So if the court goes ahead and makes that decision that nothing's in dispute here, the court then decides based on the argument whether or not the party is entitled to judgment as a matter of law. That this is clear. Given those facts, you've accepted them. So we can basically say that we're going to grant this summary judgment. All right. keep in mind that the parties just don't argue the facts here. They're going to look for, there's going to be interpretation of some important facts. If there aren't, there would be no need for the case. If we're in agreement about everything, the facts and how we're going to apply them, then there really is no case. Once you establish the law on an issue or a sub-issue, and you need to break those down and organize those, you're going to have to analyze them. So it's always the same drill. You have to kind of be guided by this. Facts, then issue at law, come up with the rule as it should be applied, as it should be determined, and then applied, right? That's what you're trying to do here. So when you incorporate in the standards of summary judgment into your argument, if you don't do that well, the argument begins to break down. So you have to remember to incorporate the standards for summary judgment in your argument, right? So there's a good example of this on page 420. It's 420, yes. Opposition facts and dispute facts. Scott papers supplied. This is an opposition fact, right? Remember, summary judgment, the judge has to be reminded periodically that there's a material question here. Remind the judge that that's the case, especially if the fact is needed to defeat a summary judgment, because you're getting both sides, right? Someone's requesting it and someone's trying to defeat it. All right, opposition facts. Scott Papers supply letter confirming the purchase agreement is dated September 1st, and Scott's distribution manager personally mailed it that day. Scott Paper Supply never received any objections to the terms of the confirmation. Moreover, Sun Printing Company concedes that it has no record of making any such objection. Okay, so obviously there's some sort of dispute here contractually. Then the dispute of the fact. In direct opposition to Sun Printing Company's assertions, this evidence shows that Sun Printing Company received the confirmation and failed to object to it. At the very least, this evidence raises a genuine dispute of fact that must be resolved at trial. Offer and acceptance. So if someone makes an offer, let's say, we're going to purchase something by this date, and they don't receive an acceptance, written acceptance or even verbal in some cases, then was there a valid contract? This is what you have to consider. Was there a valid contract? Now, is a non-response a response, right? So that's the dispute. They didn't respond, but did their absence of response constitute an acceptance of the actual contract? Keep in mind that it's subject. It's a fact in dispute, and the court has to settle that based on some standard. If you think about, there's a reason for contracts, right? There's a statute of frauds. There's a reason for that. There's always a reason, a policy issue or reason behind what the court does and how the court sort of decides these things. So that being the case, the court has to make sure, whether it's an appellate court or not, has to make sure that there is something in dispute that needs to be resolved in order to look at the question that they have to address. All right, so to prepare a motion for summary judgment, basically it's the following. First, draft a motion that requires summary judgment and briefly introduce the judge to the grounds for your motion. They want to know up front. Even if it's an office memorandum, the partners or whomever asked you to put together the brief where you're examining both sides of the argument, and fundamentally the goal is to determine whether or not to take the case, they want to know pretty much up front what your recommendation is going to be, not only because they can follow the reasoning more exactly, but because they get an answer to the question. They're not waiting for the answer. It's sort of, this is the answer, and let me explain now why I've arrived at that answer, and then let me repeat the answer at the bottom. We're more likely, we're likely or unlikely to succeed at trial. Okay, that's how it starts. We are unlikely to succeed at trial in pressing our case on blah, blah, blah. At the end, here's all the reasons. Here's our best arguments. There's their response to them. Here are the weaknesses in our argument. Here's how we have to address their argument. And at the end of the day, it's unlikely we're going to win. And then whoever that memorandum goes to is going to have to make a decision about whether or not they agree, or whether for some other reason they want to, and agree and not follow suit, or if there's some other reason. It could be any number of reasons, not just reasons that are based in the law. maybe a very wealthy client, and they have to go ahead with it anyway, or what have you. It's a fool's endeavor, but nevertheless, and it's very easy to get over your skis with that stuff. But there's any number of reasons that go outside of what is most likely to win the day. Okay, so that being the case, the second thing is you prepare evidentiary materials that will support your statement of facts if they are not already in the record. We're talking about, remember, summary judgment here. The second thing you've got to do is you've got to have evidence. Because what is it? It's facts and evidence that support those facts, and then those facts interpreted in light of the underlying law is what the court's doing and whether or not they should grant this summary judgment. So you've got to have evidence. If you don't, as I said before, there's really no point in moving forward. No evidence, no point in moving forward. Okay. The third thing is you have to draft a separate statement of facts that cites to the supporting materials. Okay, we got the facts. We got the evidentiary support. You're going to have to go ahead and draft something that's separate that shows how these two things work together. And then 4, draft a supporting brief that A, summarizes the facts and procedural history. Why is procedural history important? The judge, if on appeal, needs to know how that case got there. For example, right? They want to know what the history was. Remember, law is supposed to be about consistency. The rule of law is consistency, right? It's based on consistency. You can write all the law you want, but if it's inconsistently applied, it has no meaning. And in order to do that consistently, you're going to have to get your mind around the facts that are important and relate to the issue or sub-issue at hand, and the arguments being made by one or the other side, right? So you have to get that procedural history down. Just like it's important to get jurisdiction down and out of the way, you're going to want to, summarize those facts and procedural history so we know where they are. Okay. B, argues the law and facts relating to the issues with attention to the standards for summary judgment. Okay. The standards for summary judgment are going to be different, right? Than they will be, if you're preparing, for trial or what have you. There's going to be a difference there. So you want to show the standards for summary judgment. Here's what summary judgment is based on. Here are our facts. Here's the law we're basing this on, and you can see it's been satisfied, and it's it's consistent with the standards. So you should go ahead and do it. And then obviously you state a conclusion which says, given all the following, we should go ahead and be granted summary judgment. Now, there are a whole bunch of sample cases, that I think are important for you to look at, with exhibits and all of that, right? So it's very important to keep in mind that if you read the cases, again, the cases are nothing more than examples, right? You're given examples. And these are, it's a good one here, Arizona Superior Court, right? We've talked about this one. You'll see now, basically, summary judgment, how the introduction looks, how the argument looks, and so on and so forth. You should read this. It takes everything that, just talked about and puts it into a real case, puts it into a form so you can see what it looks like. Okay, and I don't want to go and lecture over things that you can read that are just informative and examples, but there are exhibits here. There's all of that, and it's a pretty complete request for summary judgment. Okay, so now we come to looking at evidence before trial, and the argument is that, frame it, you've got a bunch of facts. Those facts lead to a particular area of the law. We're going to assume that it's the right jurisdiction. We're going to assume all that. And now the argument is over what evidence should be admitted and what shouldn't. Remember, evidence supports the facts, right? So-and-so broke into someone's house. What's the evidence that demonstrates that? Okay? Otherwise, can you really say they broke into the house? You'd have to also define what a breaking is and so on, burglary, what have you. So the idea here is that you have to look to get rid of evidence that may be damning to your case and have the court accept evidence that supports your case. So there's going to be some argument about, this evidence cannot be admitted because of some standard, maybe, under the rules of evidence, the time frame for bringing this in has expired. So, as an example, and the rules of evidence, again, the federal rules of evidence are supported by logic and reasoning, put together by judges and by legal scholars and that sort of thing. They're not hard and fast rules in a sense, but they guide very, very effectively how we should look at evidence. So, example. So let's say that a year ago, I broke into someone's house, and now I am being charged with breaking into someone else's house. Can you bring up that first instance? Can you say, well, look, a year ago this guy did it? So at some point you have to think in the rules, well, people can actually change. And what this person did a year ago doesn't mean that they haven't been able to change, so that it really doesn't matter in this case. So where do you draw the line? All right, so let's be extreme. If something happened 30 years ago, I think we can all agree you can't bring that up. It's 30 years. People change in 30 years. Even though some people will argue people never change, 30 years is reasonable. How about 20? Probably, right? 10? Yeah, probably. 5? Still probably, right? 2? 2 is a slippery slope. So if we say 1, then that means that someone that committed that crime, found guilty of it, 360 days ago, that could be brought up at trial if we have such a rule, right? Whereas the person did the same thing, but it was 6 days more. So it's 366 days. If the rule's a year, that can't be brought up at trial. In a criminal trial, if you don't want your client to take the stand unless things are in dire straits, and you need something that might convince a jury to sort of believe this person or what have you. Because as soon as you swear that person in, what you're really saying is that they are of good character, which means now you can attack the character. Can't do that if the person never comes on the stand, because they're not claiming to be of good character, they're just there. So, and these things get a bit more complicated, but that's the function of the rules, right? All right, they're logical, they're rational. You have to have rules if you're going to have a rule of law, and rules that are consistently applied about evidence, about how a statute is read, about what's allowed in, and what constitutes the elements of that particular crime or what have you, and whether or not those elements are supported as having being satisfied by the evidence you can bring in. Look, if there are 4 elements to a particular statute, say on burglary or whatever, and you have to, the way the statute's written, you have to satisfy that all 4 have been met. Those 4 things, say a breaking and an entering, they have to be supported by facts to show that they actually occurred. Right? If they didn't occur, then that calls into question whether or not the statute is actually applicable in this situation. You need evidence that shows that happens. So suppose someone, and I've talked about this before, someone knocks on a door and the door is unlocked and opens. Does that constitute a breaking? And then that person goes in and says, hello, now they've entered. If we say they didn't break, then the entering shouldn't count, right? That's not the way it works. So I found a key on the floor outside my neighbor's house. I said, what's this doing out here? I hope it doesn't unlock the door, because then anyone can unlock the door. So they put the key in and it unlocks the door. And you knock, say, hello, and then you enter and you take the key and you put it down on a table near the door and you shut the door. Whether you lock it or not doesn't matter. You shut the door. Okay. Now you've entered, but you didn't break. Or having a key, does that constitute a breaking somehow? Now you've got to first establish that the person did those things, which are 2 of the 4 things you have to kind of demonstrate. And then, so you have to define them. And then you have to, if it satisfies the court that this is consistent with the way we think of a breaking, and sometimes it's not, and you have to convince the court that they have to view this differently. The law is not a lookup table, folks. You can't You can't say, well, that's a breaking. Here it is. It's very clear. That's the end of it. That's why lawyers stock and trade, judges stock and trade are words. We've got to define them. We've always got to define them because that's what the rule is based on. The rule of law says these facts have to be supported by this sort of evidence. And then you have to make your argument about, what statute or what have you has been satisfied. Okay, so to exclude evidence, right? Keep in mind, when we talk about in limina, right, which is, and there's a couple ways to pronounce this, Limine, and they give you Black's Law Dictionary here, but anyway, it says in limina, it is a preliminary presented to only the judge before or during trial. The typical motion is a motion to exclude evidence before trial, or at least to require opposing counsel to raise the question of admissibility outside the presence of the jury in the trial. Of the jury if the trial is underway. So basically, you can approach the judge and say this shouldn't be allowed. All right, and then the judge can tell the jury to disregard it. All right. So in contrast to a typical motion for summary judgment, a motion to exclude evidence, because we're talking about that now, right? Seeks to define the scope of the trial litigation rather than to dispose of the case before trial. So summary judgment is trying to get rid of it before trial. Now we're concerned with the trial, and what we're really trying to do is exclude evidence, right? And you do that by defining the scope of the trial litigation, and you try and get rid of, obviously, as much of that evidence that's damning to your case as possible. All right. So pretrial exclusion of evidence. The Federal Rules of Civil Procedure provide that, quote, the admissibility of evidence, close quote, is appropriate for consideration and disposition in a pretrial conference. So that's the procedure. Pretrial conference is where you can approach the court. During trial, attorneys can, and often do, object to evidence offered for admission, right? So it's not just pretrial, at trial. However, pretrial rulings on complex, potentially prejudicial, or particularly significant evidentiary matters tend to impose the efficiency and quality of the trial proceedings. Tend to improve, right? So that whole process makes it more efficient, and the trial, they say quality of the trial proceedings, but that they adhere to what we expect. Okay. Additionally, pretrial litigation of complex evidentiary matters permits more thorough written and oral arguments by the parties and more considered deliberation by the court, all without disrupting an ongoing trial. We need the court to look at this, and we don't want to keep stopping and addressing the court. Pretrial disposition of objections to particularly significant evidence gives the parties an opportunity to modify their trial strategies or to reassess their settlement positions. So put this in context. You're at the summary judgment didn't work. We said the benefit of summary judgment and the downside of that in terms of sharpening the other side's argument, knowing what the court is going to reject, and so on. That's important. Here, you're trying to figure out what evidence the court's going to accept, and things you think the court should not accept damage your case. You think they're not advancing your case in some way, and it's a complex matter. It helps sharpen your support of your evidence. These things, believe it or not, pretrial exclusion of evidence, summary judgment, it's now helping the attorneys on both sides sort of sharpen their arguments, shore up their weaknesses, go into areas they may not have considered, and come up with proper ways to go ahead and effectively attack the arguments being made by the other side. So it improves, right, the arguments. So oddly enough, trying to get rid of a case in summary judgment, have the court get rid of it, or trying to get rid of evidence being admitted, actually helps both sides refine their arguments. Now, you don't wait to have a refined argument to do that. This is going to the next level with summary judgment, and now with the excluding evidence before trial, a motion to exclude evidence before trial. Think about it. You know what evidence the court's going to have an issue with, and that's important in terms of your facts. And you also know what the court will not accept as an argument for getting rid of the case. So it benefits you. I said last time about looking for summary judgment. There's an upside and downside to it. Here, there's less of a downside because you need to know what evidence is going to be accepted by the court. So you sort of have to have that in place. I think there's less of a downside to doing that. So unless the court rules specifically, addressing motions of Lamaya, you should follow procedural rules governing motions generally. Beyond that, the common format is a product of custom and common use. This is not boilerplate, but the process. Here's how you do this. This is what it includes, and you'll see there are examples of this that you should look over. So you follow those. You don't want to reshape or reinvent things that don't need to be reinvented, right? But you don't want to accept things boilerplate because, well, it's done this way. I can just throw all this in. Lean, focused, moving your argument along is what you want. Okay, you don't want to burden the court by deviating so much from the standard that you're not as effective. And you don't want to burden the court by just following a boilerplate because it covers everything, some or most of which is not relevant. When you put together a motion, whether it's for summary judgment or to exclude evidence, this is the first time, really, right? The court gets a look at you, and so the court is, I think, either going to be impressed. Impressed is not the best word. They're going to start beginning to not only understand, but maybe give more weight to your argument if this part, the motions, are well designed, well written, well organized, clear, concise, prepare the judges to make a decision, right? If you think about, the Supreme Court, those briefs are really important because the judges will all read that stuff. Actually, they'll have their law clerks read it. There have been exceptions where some justices say, I want to read the whole thing, but they have law clerks. And that's a bit of a misnomer. These court clerks are people that did very well in law school and beyond, and so they're not filing paperwork. They know the justice that they're working for. They know what kinds of cases they're interested in. They know the general nature of how they approach cases. So you get each of these law clerks looking at this and then making a recommendation. This is something you might want to look at to the justice, and here's why. So they're going to send a brief, and so what's going to happen is that justice is going to read it and say, yeah, not so much, or yeah, I really want to have these guys come and make an oral argument, or I think we should write a decision, or just overturn it and say nothing about it. They have a whole range of things they can do. In the Supreme Court, the full process is that the court says, send us the paperwork. Court decides to take it, and wants oral arguments. That's the full thing, right? You get all the way through to oral arguments, and the other side is notified you've got a certain period of time to get in your briefs, obviously to tell us your side of the story. So the justices, if they give it, and that's what we're really concerned with, we want decisions of the court written up because those are the most instructive. The court, as I said, can also just say, reversed and not say anything more. Those aren't so instructive because we don't know why the court wanted to reverse the lower court's decision. But when you have someone come to the court, before the court, make oral arguments, and the court then writes a lengthy opinion that other justices either support or don't support, right? That in the majority or they have a dissent of some sort, you get a full and better, more complete understanding of how the court defines these things, whether it's the statute or the arguments or the words in the statute or the evidence that the court finds persuasive. Keep in mind the case of the Supreme Court, like most when sitting as an appellate court in most appellate courts, the justices have already read all the paperwork. They've read all the motions, right? They know the history, right? They understand jurisdictional issues and all of that. That's out of the way. By the time they get to oral arguments, the justices are not interested in rehashing what was there. They know what was there. They have questions now, and they're going to challenge you on your position or positions on various issues. They do that sometimes, as I mentioned, to weaken your argument before the other justices, to try and get those justices to take their position, what they think should happen. Or sometimes they'll aid counsel in asking questions and helping them interpret it in a way that they can influence the court or other justices to sort of take their position on it. So if you don't agree with the appellant, right? Then you're going to try and attack that case, weaknesses in that case. If you don't agree with the appellee, then you're gonna have also either a justice ask questions that will support or weaken that argument, trying to convince other justices to take their position. So justices have already pretty much, in the Supreme Court and appellate courts, they should have already pretty much formed. They're not going to oral arguments because they don't know what to do. They're looking to be persuaded themselves, and they're looking to have questions answered that will help them make a decision or help other justices come to their side, whether it's a majority or not, whether it's a dissenting opinion, it doesn't matter. All right, so keep in mind, local court rules, are what you care about. You want to be consistent with where you are. And every court, Supreme Court has their ways of doing it. They want things done in a certain manner, and that's the way they have to be done. Even citing cases, I think I've already, held up the blue book, thick, laborious, and it changes about how you go citing cases that you're using to make your argument. So you want to know what goes on in local court. So lawyers obviously admitted to the bar in that state, limited to that state. That's what we're talking about now. New York is a jurisdiction that, you got to pass the New York bar if you want to practice law in New York, and you're an attorney that is from another state. Okay, so basically, you want to stick with what the court's used to seeing because that's going to make things easier and is going to make things clearer. But also, more importantly, keep in mind that if you don't do that, it shows some lack of understanding of how things work in that particular, local, court or jurisdiction. And typically, lawyers that pass the bar in a state, they operate in certain jurisdictions, right? Although they can operate throughout the state, they handle certain types of cases in typically certain jurisdictions. So they should be well familiar with all the processes and other lawyers. And these lawyers are going to meet up again, more than likely. And so there's a level of maybe camaraderie goes too far, but there's certainly an understanding that I've got to be careful how I proceed and behave, ethically and all that. But even beyond that, because I'm going to see this attorney again, and we're going to be at it again. And so I want to have a reputation of not only being someone that's thorough and forceful, but also someone that follows ethical guidelines and is deferential where they need to be deferential, right? You don't go in like a bull in a china shop. All right, so the motion. In a motion to exclude evidence, you should simply and clearly state the action requested and briefly summarize the grounds for motion. In describing the relief requested, you probably should go beyond generally asking for exclusion of certain evidence. This is on page 439. To ensure effective protection, you should describe the objectionable evidence as inclusively as possible and should request an order specifically prohibiting the opposing party from referring to the evidence. Here's a little example. The defendant, Axon Corp., moves for a pretrial order excluding all evidence that Axon Corp. Offered to provide medical care and to pay medical expenses of the plaintiff, Herb Taylor. The evidence is inadmissible under Federal Rule of Evidence 409. So you go to 409, you see what that rule is. Okay, so here we go. Specifically, Axon Corporation requests an order directing Taylor and his counsel, 1, to refrain from referring to such an offer in any way in the presence of the jury during voir dire and all subsequent proceedings. Voir dire is where attorneys from both sides look at people that are going to sit on the jury and they ask them questions to see if they want them to sit on the jury. There are a certain number of freebies that each side gets where you can just dismiss and say, I don't want this person on my jury. You don't have to give an explanation for it. You're not fighting it out. Each side gets a few gimmies like that. Well, okay, I really wanted that person, but this person, the other side said no, and they have a right to say no. Once they go past that specified numbers, now you're going to have to argue with the other side if they want that person on the jury, right? So during voir dire, they don't want the jury to hear, or see what they're doing, right? They don't want that to happen, so they're not around, right? So you don't want any evidence presented, right? You don't want them to know what evidence you have, but you want to vet them and find out what their position might be or what this person is sort of thinking. So if it's a criminal matter, let's say, and they ask you, do you know anyone that's ever been convicted of a crime? What crimes? And it turns out the crime that this person's sibling was found guilty of is pretty much the crime that this jury is going to be hearing. You don't want that person on the jury. They're already predisposed to it. They may already have a feeling about how, say, their sibling was treated. So in some ways, you want a blank slates, and the attorneys want an opportunity to sort of convince them, right? To ensure effective protection, right, in the matter here, you have to go a little bit beyond that. The second thing is to take all necessary steps to ensure that their witnesses avoid such references. Okay. To oppose a motion to exclude evidence, you need not file a separate motion. You can simply file a brief that opposes the original motion. At most, you might want to draft a cover page with a caption and paragraph that parallels the motion in summarizing the rule you seek and the supporting grounds. So plaintiff Herb Taylor opposes defendant Axon Corp's motion to exclude evidence of Axon Corp's offer to provide and pay for medical care. The evidence is admissible to show the extent of Taylor's injuries. The court should not exclude the evidence for this limited purpose. So there's a small reason why we're doing it, okay? The next piece is the brief. A brief supporting or opposing a motion to exclude evidence or any other motion is often referred to as a memorandum of law. When preparing a brief supporting a motion to exclude evidence, you ordinarily should follow the familiar pattern of introduction, argument, conclusion. It's the same drill, okay? The party opposing a motion should file a responsive brief that directly answers the arguments in your supporting brief. They don't need to go beyond. You don't go beyond. They said that, we're going to address that issue. On motion for summary judgment, you will address at least some of the claims of defenses of litigation on their merits. In contrast, on motion to exclude evidence, right, you will typically focus more narrowly on the admissibility of certain evidence, and there you're going to rely on the federal rules of evidence, which is not the only source that courts follow, but it is the major one. All right, so in the introduction, what do you get? In the introduction section of brief supporting a motion to exclude evidence, you need not exclude a full statement of facts and procedural history, right? In light of the motion's focus on an evidentiary issue, your introduction needs summarize only those portions of the facts and procedural history necessary to an understanding of those portions of, only to those portions of the facts and procedural history necessary to understand that specific issue. You should accompany your motion with the necessary factual support for your assertions, such as affidavits or documents generally during discovery or prepared specifically for the motion. Look, there's evidence. You have to have evidence. And part of the discovery and affidavits and depositions, all of this is about getting the evidence you need, right, to support your argument. So obviously, if you're in your introduction, this is what you're focusing on. You should cite to such attachments or order or to other parts of the record, absent a local rule specifying a particular format. Any reasonable citation is acceptable. There's two examples that are given on page 440, and it continues through 441. And it breaks it down. Again, you really should read and work through these examples because they help you understand how this thing gets structured. Again, I'm not going to work my way through those because they are pretty clear. So you would read the introduction, right? And listen to the lecture, and then you would go back and you would look at how that's been put together in the example, right? This is a memorandum in support of motion to exclude evidence. Starts at the bottom of page 440. Okay, so you don't need to you don't need to do much more than see how that example works. The next part, obviously, is the argument. Introduction, argument. All right, so here's something that's important in the argument. You always want to have you discuss sort of the rules application, right? And you also want to discuss what the legal rule is. In other words, in your argument, you're going to have to bring together two things. Keep evidence in the back of your head at this point. you need to be able to look at those legal rules, right, legal standards and the like, to exclude evidence, and you focus on the rules of evidence that restrict admissibility. You follow rules of evidence, and you look at, okay, on what grounds can I get rid of, evidence and say it's inadmissible? So you're going to have to go ahead and cite those things and say these are the legal rules, right? So here's a brief little thing that kind of explores that a bit. You know what? I'm gonna leave that to you to actually look at. It's better for you to look at it as an example. Then the application of the rules to facts, right? So you got the application, right, of the rules, and you need to kind of make the determination or show that these things are associated. So as in a legal argument, the fact analysis should lead to a conclusion by relating the facts to legal standard. It's the same drill, and there's an example of that, right, which you should read. So you're doing the same drill. The same drill is you've got the introduction, you've got to have the argument, you're going to have a conclusion. These things belong in the introduction, these things belong in the argument, this belongs in the conclusion. When you read the examples, you'll see how they structure that and how it's written, but you have to understand that you're making a decision about what goes into each one of those three sections, the introduction, the analysis, and then the conclusion. All that has to advance your argument for, in this case, excluding evidence. So in the conclusion, what do you want to do? You want to end each argument in a brief with a conclusion on the argument, and to end the entire brief with a general summary of all the arguments and with your request for relief. What you're trying to do here is you're dealing with each piece, right, as you go through, and then you're going to go through and you're going to, at the end, give a general summary of why these things need to be in tandem or what have you, be removed, piece of evidence be removed. All right, so there's a pretty good summary on page 444. To prepare a motion to exclude evidence before trial, draft a motion that simply and clearly requests the court to exclude specified evidence and to prohibit the parties from referring to the evidence at trial. 2, draft a supporting brief that introduces, here we go, the facts and procedural history relevant to the motion, how we got here, right? Second, argues the law and facts relating to the evidentiary issues, right, which is looking at those rules and how they apply, and states your conclusion. Then finally, attach any documentary evidence or affidavits necessary to support your motion. Okay, look. Then after this, you're going to have a sample of it's Deborah E. Driggs, right? Superior Court again, as Agrafria, Sand, and Rock Inc. And there you see it all laid out for you. And they'll say factual background, include the history there. They'll lay out the argument, right? And when you get to the end of that, you'll see how all this comes together. All right, so look, we've talked about previously, advocacy. We talked about, in the light of that, someone, a complainant coming forward and issuing a complaint, writing all that up, getting a lawyer, and so on. And then the answer to that. And then, okay, now we've got that. Let's see if we can get summary judgment. And if you don't, you're going to trial, and then you're turning your attention to, getting rid of evidence you think, is going to hurt your particular case. So that's the drill. That's basically how these things, come together. Again, very simple. Sounds simple, but very simple. The structure, the order of things. Complaint, no case. Nothing to discuss. Complaint, which must have somehow you've been aggrieved and the relief you're looking for, and if you remember all the things we went over. Then an answer, which can have a counterclaim in it, right? Trying to get, addressing the other issues, stating what they've agreed on in terms of what facts and so on that they're willing to, not argue out. They both sides accept it. And there might be a counterclaim. The other side then, the side that filed the complaint gets to address that counterclaim. Now, at that point, at any point along the way, these parties could settle and everything just stops. So now the answer is in, the complaint is filed, the answer is in. Now let's see if we can get this thing summaried out. Let's get the judgment. Let's have the court throw it out. And then there's a procedure for that. And then that not occurring, then you would move to trying to get evidence excluded. And of course, part of the process there is you're beginning to pick a jury, right? And you're trying to figure out which members of the jury you should, who you should put on the jury and who you should not. So, for example, even though lawyers are supposed to be in the jury pool, I think that that still remains. You don't want to ever call a lawyer and put a lawyer on a jury, because then people on the jury know the person's a lawyer, and that person's going to influence. And lawyers don't want to do it. So it's done to make things seem fair, but at the end of the day, you're not going to call it. You're also not going to call people that teach this stuff, even though they're not practicing lawyers, because they already know a lot, and you don't want them influencing the jury. So oddly enough, the people most in the know, or the people best versed in these sorts of things, are not people you want on your jury, which seems counterintuitive, right? You'd want people like that, but that's not the case. All right, that ends this lecture, and we'll pick it up after the midterm.